afternoon, Namibia and the world, and welcome to our Thursday and last edition of the JIC sessions for the week. I am Desire Shianwa Kahiha. I am your moderator for this afternoon, and the topic this afternoon we're looking at the Labour Commissioner's mandate. Yes, the Labour Commissioner's mandate, and I have three panelists in the studio this afternoon who will be helping us to understand what it is that the Office of the Labour Commission does and what is their actual core function and mandate and how that would relate to us as Namibians. And we have Mr. Henry Carson. He is the Labour Commissioner from the Office of the Labour Commissioner. Good afternoon, Commissioner.
Afternoon.
Then I have Ms. Kailiki Sihlahla, and she is the Deputy Labour Commissioner. Good afternoon.
Good afternoon.
And then I have Mr. Liwela Sasele, and he is the Acting Deputy Director for Conciliation and Arbitration in the Office of the Labour Commissioner. Good afternoon.
Good afternoon.
As we know by now, we do our weekly COVID updates every Thursday. Those will be coming a bit later on in the show as we receive them. For now, we get back to our topic for the afternoon. You are welcome to comment, to ask questions on our social media platforms. On Facebook, you can find us on Ministry of Information and Communication Technology, Republic of Namibia. That is on Facebook. We are live streaming through these platforms, so we will be receiving your questions and we will pose them through to the panelists. And on YouTube, that is also another platform where you could find us, and our handle on YouTube is MICT Namibia, MICT Namibia. We kick off the session, and our first question goes to the Commissioner, as we want to find out from Mr. Carson, what is the mandate of the Office of the Labour Commissioner and where is it derived from? What are the functions and the powers of the Labour Commissioner?
Well, thank you very much. Good afternoon, listeners. The Office of the Labour Commissioner is situated in the Ministry of Labour as a department under the Ministry of Labour. We, of course, then contribute towards harmonious labour relations by operating the ADR system that is implemented in Namibia in terms of the Labour Act. ADR is Alternative Dispute Resolution System, and essentially revolves around conciliation and arbitration. That's one of the mandate of the office, is to manage the compulsory system of arbitration and conciliation. Then the office also, as part of contributing towards harmonious labor relations, also deals with collective labor relations. That is the registration of trade unions and employers' organizations, and to monitor the compliance of such organizations in terms of their registration. Further, in terms of contributing towards harmonious labor relations, we also deal with issues of retrenchment. It's called collective dismissals in the Act, but commonly known as retrenchment. So by law, we have to register all retrenchments that takes place in Namibia. So retrenchments is also part of our mandate. Then we do, in terms of industrial relations, we do monitor and record strikes and lockouts also in industrial action, which includes strikes, lockouts, and sometimes demonstrations, labor demonstrations. So our mandate is then derived basically from the Labour Act under the Ministry of Labour, Industrial Relations and Employment Creation. Well, the functions of our office is specified in Section 121 of the Labour Act. I've indicated that our mandate is founded in the Labour Act. So what we need to do will also be found in the Labour Act. So under Section 121 of the Labour Act, we have a number of functions that we perform. Uh, of course, chief amongst them is the function of managing conciliation and arbitration. Then we also deal with issues, as I've said, issues of collective labor relations, registering trade unions and employees' organizations, and also managing and recording retrenchments or collective termination of employment. In terms of the Act, there's also a function that the Labor Commissioner may assist in training employers and trade unions in terms of the rules of the Labor Act, in terms of registration matters, in terms of designing the content of collective agreements, which the employer and the employees are signing, or the unions and the employers. And then, of course, dismissal procedures, which is to be followed when employees are dismissed or employer wants to embark on dismissal. So that is, in short, our functions. You can refer to Section 121 of the Labor Act. It is there. There are, of course, scattered, or not scattered, but functions that is not under Section 121. For instance, in terms of collective termination of employment under Section 34 of the Labor Act, an employer may not embark on retrenchment of employees unless they notify the Labor Commissioner within 4 weeks before the retrenchment takes place. So that is a function that is based on Section 34 and not necessarily under Section 121, which is the core or the main section dealing with the functions of the Labor Commissioner.
Okay.
Thank you.
There we have it. We have now gotten an idea of what it is that the Office of the Labor Commissioner does, where it has been established from, their functions and so forth. Before we continue with the topic for this afternoon, we do have our weekly COVID-19 updates that have now been moved to Thursdays instead of having them on a daily basis. And with us in the studio, we have the Deputy Minister of Health and Social Services, that is Dr. Esther Mwinyangwe, who will be delivering this update for us. Good afternoon, Doctor. How are you?
Good afternoon, Madam Kahia, and thank you very much for having me. And my apology for coming 5 minutes late.
Apology definitely accepted.
Thank you very much. And that apology also goes to our viewers and listeners. And I should say that after 2 months, I'm happy to be back.
Yes,
and do the
please.
update. Thank
We're
you very
happy
much.
to see you again.
Thank you. So, fellow Namibians, for the past week, that is now the period between 28 July and the 3rd of August, 2022, we have recorded 65 positive cases from 1,622 tests conducted, representing 4.0 positivity ratio. Of these positive cases, 63 are new cases and 2 are reinfections. The sex distribution is 46 males, of which 45 are new cases, and 19 are females, of which 18 are new cases. The age ranges from 3 days to 88 years. The new COVID-19 positive cases and reinfections are distributed as follows. Erongo, 22, Comas, 13, Omusati, 8, plus 1 reinfection, making the total from Omusati 9. Omaheke, 7, Oshikoto, 6, Sambesi, 3, Kunene, 1, Ohangwena, 1, Oshana, 1, Oshodonjupa, 1. Karas did not record new infections, but they are recording 1 reinfection. Cases were reported from 11 regions. Among the confirmed cases are 14 learners, 3 students, and 2 teachers. Of these cases, 4 have received 1 dose of the COVID-19 vaccine, 9 are fully vaccinated, of which 6 have received a booster dose as well. 11 are not eligible, and 41 were not vaccinated. We recorded 32 recoveries from 8 regions during the reporting period, and the recoveries are as follows, as from the regions. Komas 11, Omusati 8, Erongo 4, Ohangwena 3, Sambesi 2, Karas 2, Omaheke and Oshodonjupa has recorded each one recovery. As of 3rd of August, the number of active cases is now 131. 7 cases are hospitalized in 5 regions. 1 of the hospitalized cases has received 1 dose of the COVID-19 vaccine, while 1 case is fully vaccinated. The distribution of hospitalization is as follows. Oshana 2, Sambesi 2, Oshodonjupa 1, Ohangwena 1, Oshikoto 1 as well. We recorded, on a sad note, 1 COVID-19 death during the reporting period. A 36-year-old female from Enana district with underlying medical conditions who died at a health facility on 28 July 2022. The deceased was not vaccinated, and as a ministry, we express our sincere condolences to the bereaved family. By the 3rd of August, a total of 5,018,943 people aged 18 years and older have received 1 dose of the COVID-19 vaccine, representing 35.3% of the target population. A total of 189,141 have received the Johnson & Johnson vaccine, while 267,923 adults have received 2 doses of other vaccine types. Hence, 457,064 adults have completed their vaccination, translating to 31.1% of the target population. 24,843 children aged 12 to 17 years have received 1 dose of the Pfizer vaccine, representing 8.1% of the target population. The target population for the children is 307,298. Of these, 12,778 are fully vaccinated. Hence, the cumulative number of people vaccinated with the first dose of the COVID-19 vaccine for both adults and children is 543,786, of which 469,842 are fully vaccinated, translating to 26.4% of the total target population. 83,245 people have received a COVID-19 vaccine booster dose. As I'm moving towards conclusion, I'm giving now the summary of the national update. Cumulative confirmed individuals, excluding reinfections, is now 166,530. Cumulative cases including reinfections, 169,571. Recoveries, 165,352, giving us a recovery rate of 97.5%. Active cases, 131. Cumulative COVID-19 vaccine first dose, 543,786. Cumulative COVID-19 vaccine second dose, 280,701. Cumulative COVID-19 vaccine completed, 842. COVID-19 deaths, 3,719. COVID-19 related deaths, 354. And that gives us a total of 4,073 deaths. The total samples that have been tested is 1,071,116. Madam Kahia, that concludes the update for today. Thank you very much.
Thank you very much, Dr. Mwinyangwe. We are always happy to have you in our studio. At least we always know that when you're around, we are up to date.
Okay.
Thank you.
Thank you.
Until next week, then, hopefully.
All right, thank you.
Okay.
Bye.
Getting back to our topic here in the studio, as we said, we're looking at the Labour Commissioner's mandate. And I have three panelists here in the studio. We have the Commissioner, we've got the Deputy Commissioner, and we've also got a acting Deputy Director, that is Commissioner Henry Carson, and we have a Deputy Labour Commissioner, Ms. Kailiki Sihlahla, and Mr. Liwela Sasele, who is the acting Deputy Director for Conciliation and Arbitration. We said that you could be part of this conversation, as always, and you can join us via our social media platforms. That is Facebook. You can find us at Ministry of Information and Communication Technology, Republic of Namibia. Ministry of Information and Communication Technology, Republic of Namibia. On YouTube, our handle there is MICT Namibia. MICT Namibia. Coming back to our questions that we have, Ms. Sihlahla, what type of advice can the Labour Commissioner give with regards to labour matters?
Okay, thanks very much for the question. The Labour Commissioner may provide advice to any person that is seeking for advice. However, providing advice is quite limited in the sense that we wouldn't provide advice on the merits of the case, since the case has to be heard independently in the presence of both parties. However, we provide advice on rules and procedures that are to be followed, because sometimes there are issues that, for example, the public is not aware, or the public does not know how to handle them. So when they approach the Labour Commissioner will then advise them on, for example, if it's a dispute that should be referred to, explain the forms, how they should be filled, and how to go about now referring such dispute. And if it is, for example, a dispute that the Labour Commissioner does not have a jurisdiction to deal with, would then advise them to approach the relevant authority.
Okay.
Importantly also that sometimes we find the public coming saying, no, the Labour Commissioner is not there for us because we have got our disputes and the Labour Commissioner is not ruling in our favor. We are not there to represent parties when they refer their disputes, but to adjudicate on the dispute, or to preside over the dispute and then make an independent decision, and or to provide them with an opportunity to see whether they can resolve the matter on their own.
Okay, okay. Mr. Sasele, once a case has been referred to the Labour Commissioner, how does the Labour Commissioner deal with such a case?
By law, all labour disputes are referred to the Labour Commissioner. Once received, they are screened to make sure that they comply with the time frames, to make sure that they are referred by people who are authorized to refer disputes on behalf of the parties, and also to make sure that they were saved. The referral was saved by the referring party to the other party to the disputes. Once the Labour Commission is satisfied that everything is in order, it is a dispute it is the labor commissioner will designate a conciliator
Yeah.
to conciliate the dispute, or an arbitrator to arbitrate the disputes, depending on the nature of the dispute.
Okay, okay. And we are here to educate and get educated. I think that is the one thing that I always appreciate about this platform. We get to learn new things every single time. Mr. Carson, are there any limitations on the Labor Commissioner's jurisdiction to hear matters? And what happens in cases where the Labor Commissioner might not have jurisdiction to deal with aforesaid matter?
Thank you very much for the question. Yes, there are definite limitations in terms of the Labour Act and in terms of the functions are placed on the Labour Commissioner. One look at I think, at the Act from the beginning in terms of Section 2, Section 3 to 5, actually Section 2, there's a definition of which industries fall under the Labour Act. Now, Defence Force, police, central security, they do not fall under the Labour Act for normal disputes, because they have their separate laws, and of course they are part of the defence system of Namibia. However, in terms of Section 3 to 5, there are certain disputes concerning discrimination, child labour, forced labour. Those ones include the Defence Force and the police and so on, only in respect of those specific cases of unfair discrimination, child labour and forced labour. If there's any disputes about that, then it can be referred to the Commissioner. But otherwise, those are the Commissioner's jurisdiction in respect of disputes from police and the army is excluded, and central security, of course. There are also then provisions that in terms of Section 91 of the Labour Act, which is very not known, generally known. In terms of Section 91 of the Labour Act, the employer and employee or the union can agree in terms of a collective agreement for private arbitration. Now, I've said the arbitration conciliation that the Labour Commissioner's Office provides is compulsory in terms of labour disputes.
Yeah.
But they can opt, in terms of a collective agreement with the union and the employer, that they take their disputes to private arbitration, not to the Labour Commissioner. So then, in terms of that provision, the limitation, the Labour Commissioner's jurisdiction is limited. Yeah. We cannot get involved there. Then, in terms of Section 86 of the Labour Act and Section 86 of the Labour Act, there are the jurisdiction to hear cases that is older than 6 months if it is unfair dismissal. Yeah. Is limited. A case older than 6 months, when it's an unfair dismissal, cannot be accepted and heard by the Labour Commissioner. A case, you must report your dispute if you are unfairly dismissed within 6 months. Okay. After 6 months, the Labour Commissioner's jurisdiction is limited. We can't receive or handle the case. For any other labour disputes, in terms of Section 86 of the Labour Act, any other is 1 year. So there's a time limit of 1 year. So if a person have a dispute, a labour dispute, and wants to refer it to the Labour Commissioner, if it is not unfair dismissal, any other, like your leave is not paid, your salary is not paid, you didn't get overtime, that type of disputes must be referred within 1 year. After 1 year, the Labour Commissioner's jurisdiction also is limited. It can't be heard under the dispute settlement process of the Labour Commissioner. Then, of course, there is issues of criminal and civil cases. We have strange requests for, especially people that, generational farm workers, for instance, that's a term that they use, where a farm worker stays on a farm from a kid until an adult, and then the services are terminated, and the farm worker would then want to come and make a dispute to have part of the farm, because they, as generational farm workers, they can sometimes get a portion of the farm in terms of inheritance or in terms of land redistribution. We can't deal with that because it's a farm laborer, but it's not a labor case. So it's important that we understand the limitations to the jurisdiction of the Labour Commission. They are, of course, also independent contractors. That is a person that does piecework, legally defined as a person who are not under the direct control of an employer. We, in the region where I come from, Hartap Karas, we have a lot of bakkie builders, they call them. They do stukwerk, part work. So that is an independent contractor, and they are engaged for specific work for a specific amount. They don't work regularly like hours, 8 to 5 and so on. So people who are doing that type of work are also not, can also not refer a dispute, and the Labour Commissioner's jurisdiction is limited there. Thank you very much. It's a mouthful.
Yes, it is a mouthful that was necessary, because I'm sure a lot of people, as you say, you get these cases, they are coming to you, and I believe that is due to the people not having the knowledge of what you can and cannot handle. Please do communicate with us. I'm sure there are many out there that would love to ask questions to the panelists that we have today on this particular topic. Our call-in line is 061, that's the area code, and the number is 400-397. 400-397. That's the number here in the studio. Our lines are open for you to communicate, ask your question, or make the comments that you need to make to be part of the conversation. We continue with Ms. Sihlahla, and we would like to know from you, can the Labour Commissioner delegate his or her powers? If so, to whom?
Okay. Thanks very much for the question. In terms of Section 122 of the Labour Act, the Labour Commissioner may delegate any function to an individual within the ministry. And the Labour Commissioner also, when he receives the labour disputes, because all labour disputes are referred to the Labour Commissioner, he or she then delegates certain functions, for example, for conciliation and arbitration, by designating an arbitrator or a conciliator to preside over a matter. And also you have also a function of registering trade unions. So the Labour Commissioner may delegate such function to, for example, in our case, to police analysts to scrutinize the constitutions that are submitted to the Labour Commissioner, and then provide the Labour Commissioner with a report to then determine whether to register such trade union or not. And then that is a delegated function. We also have a function that is delegated is to notify the parties, because the Labour Act provides that the Labour Commissioner must notify the parties of when the matter is going to take place, where and at what time. So such function is delegated to the administrative officers so that they can then notify the parties. So in a nutshell, the Labour Commissioner may delegate certain functions to individuals within the ministry.
Okay, okay. Mr. Sasele, we are still with you.
Yes.
We haven't forgotten about you. And we want to find out from you, what are the processes involved in solving referred disputes?
Thank you very much for the question. The process involved depends on the nature of dispute that was referred. There are two types of disputes. One is a dispute of right, and the other one is a dispute of interest. If it's a dispute of interest, the Labour Commissioner will refer it to a conciliator. So they have to take the route of conciliation. And if it's a dispute of right, then the Labour Commissioner will refer who designate an arbitrator who resolve the dispute through arbitration. So it just depends on the nature of dispute that was referred to the Labor Commissioner.
Okay. Okay. Mr. Carson, what happens in cases where the Labor Commissioner might not have jurisdiction? No, pardon me, I think we answered that one. We then move on to the next one. I think that one I'll refer to Ms. Sihlahla. Who can refer a dispute to the Labor Commissioner?
All employees and employers in Namibia may refer a dispute to the Labor Commissioner. But then with the limitation or in terms of Section 2 of the Labor Act, the NDF employees, the correctional services, the policemen and women, they are limited to refer only certain disputes to the Labor Commissioner. And he has also indicated, the Labor Commissioner has also earlier indicated that the independent contractors do not refer disputes to the Labor Commissioner. And we have got also currently members of trade unions, when they feel that there is an unfair labor practice, in the sense that their trade unions did not represent them fairly or adequately, they may also refer their disputes to the Labor Commissioner. And also, in terms of the Labor Act, if an employee dies while in employment, severance payment should be paid to the surviving spouse or the children. In the event where the employer has failed to pay the compensation, the severance paid to the spouse or the children, the surviving spouse or children, then the spouse or the surviving children may refer a dispute to the Labor Commissioner.
Okay. I'm going to throw a spanner in the wheel here. You mentioned situations where union members, when they feel that their unions didn't represent them, they too can register or report or refer a dispute with the Labor Commission. I'll make a hypothetical example of, let's say, for example, today we had two parties that had a presentation that they made with regards to consensus that they have reached on a particular matter. What if you have union members that feel that their union, before signing off this particular agreement, they were not consulted? Does that validate them approaching the Labor Commissioner?
What I may say is that, for example, you approach your trade union that you've got a dispute, and the trade union did not refer your dispute to the Labor Commissioner within the prescribed time period, and by the time you follow up, the prescribed period has lapsed. And then as a result, the Labor Commissioner does not accept your dispute anymore because your matter has prescribed. Yeah. So you may now sue your trade union for failing to refer your dispute to the Labor Commissioner on time. Okay. In the event whereby you feel that your union maybe did not, for example, consult you and so on, you still have to engage your trade union and see what really happened and so on. And then you see whether there is a case or not, and then you'll then decide on what the next step to take. Okay. Yeah.
Okay. Mr. Sasel, there were two time frames that Mr. Carson mentioned with regards to time frames within which disputes should be referred to the Labor Commission. It was a 6-month time period, that is with regards to unfair dismissal, if I'm not mistaken, and Another time frame was about a year. Apart from these two time frames, are there other type of disputes that have their own sort of time frames allocated to them?
Thank you very much. They are the only two time frames that we have in the Labour Act for unfair dismissal. As he rightly said, is 6 months, and any other dispute should be referred to the Labour Commissioner within a year.
Okay, okay. But staying with you, Mr. Sasele, do we have incidences where the Labour Commission does condone a late referral or entertain one? If yes, under what circumstances are those?
The short answer is no. The Labour Commissioner does not condone, and someone might ask why. It's because there is no provision for condonation in the Labour Act.
Okay. There's no provision.
Yes.
But if there is no provision and I am said that I can register a dispute, then why is there a time frame?
Yes, there is a time frame to prevent people. No, if a person is aggrieved, an employee is aggrieved, the employer is aggrieved, suppose he was dismissed, why should such a person stay for 2 years if he is aggrieved without referring the dispute to the Labour Commissioner? So there is that time frame that as from this time, you are not allowed to refer the dispute.
But again, we come back to the matter of not everybody is as educated about these matters as others, and maybe only after a year and a half do they come across somebody who does actually give them guidance on what they could have done or what they can do.
You know, in such a situation, the Labour Commissioner will not accept such a referral, but the parties, they still have a right to approach the Labour Court.
Okay.
The Labour Court might direct the Labour Commissioner to accept the referral.
Okay, so there is still an option.
There's still
that
an
they
option.
can embark on, not necessarily straight to the doors of the Labour Commission after that particular time frame, but they still do have somebody they can approach. I think that was my biggest question there, as in, if my time frame has lapsed, what do I then do? Do I just go sit at home and I am now unemployed without my salary, or my salary was cut by half? You know, that was the gist of that question that we were trying to get to. As we say, it's conversations that we have here at the Government Information Center, and it is platforms through which we educate ourselves, we educate you, we educate each other, and thus we always invite you to please join the conversation. You can find us on our Facebook platform, and our handle there is Ministry of Information and Communication Technology, Republic of Namibia, Ministry of Information and Communication Technology, Republic of Namibia. You can find us on our YouTube channel as well, and there our handle is MICT Namibia. MICT Namibia. You can give us a call in the studio, and the call line number is 061, that's the area code. The number itself is 400397. 400397. While we wait for you to join us here in studio with your comments and your questions, we move on, and we would like to ask Ms. Sihlahla to assist us with regards to who can sign the referral. And here we are looking at the form referenced LC21 and all relevant documents.
Thanks very much for the question. But before I answer that question, I would just like to kind of touch on the previous question that you posed regarding the condonation. The Labour Commissioner operates within the purview of the Labour Act. The Labour Act does not make provision for condonation. Although you find condonation being stated in the rules, in terms of the rules, condonation may be granted. But in terms of the Labour Act, for example, whereby there is a time frame within which a party may refer a dispute, the Labour Commissioner has got no jurisdiction, has no power to condone a late referral. And if he happens to attempt to condone, then that would mean that the Labor Commissioner is exceeding his powers and is acting ultra vires. Going back to the question as to who is authorized to sign, in terms of Rule 5, an employee or a party that refers a dispute to the Labor Commissioner, such party is authorized to sign the referral. If, for example, the referral, it contains a number of parties, then they have to authorize one of the applicants to sign the referral on their behalf. And they must indicate clearly that we are authorizing Mr. Liwela Sasele to sign all the documents and to refer the dispute to the Labor Commissioner. And they have to sign that authorization. They all have to sign the authorization. And again, if the applicant is a member of a trade union or a member of the employers' organization, then the office bearer of such a trade union or employers' organization may sign the documents on behalf of the applicant. A co-worker also can sign a referral on behalf of the applicant who is an employee, and also on behalf of the company, a director or any employee of the company who is authorized to represent the company may also sign the documents if, for example, it's the employer who is referring a dispute. You may ask what type of dispute may an employer refer. Yes. For example, if you look at when an employee is resigning, in terms of the Labor Act, an employee is required to give notice when resigning. You find sometimes an employee just, I get my salary today, end of the month, and then tomorrow I'm not coming, or I'm tendering my resignation, I'm resigning with immediate effect because I maybe secured a job elsewhere. So the employer may now refer a dispute to the Labor Commissioner for that employee to pay the notice in lieu of to pay in lieu of the notice that the employee ought to have given to the employer.
Wow. Whoa. We think it's just cut clear and so on, but we never really consider the nitty-gritties when we're taking our actions sometimes. So thank you very much for letting us know some of these things. Now in the future, we know what we need to be careful of.
Employees engage in illegal strike. So the employer may, refer a dispute. So there are so many types of dispute that any employer may refer.
Yeah. So, as I always say, let us educate ourselves. These are all things that are part of our lives. And you might think that it's not affecting you, it's affecting your neighbor, but you never know when the day comes where you are affected by these problems. Mr. Carson, what remedies are available to a person who is aggrieved by a decision made by the Labor Commissioner?
Thank you for that question. I think what we find recently, and I think the public or parties sometimes out of sheer ignorance considers that if they're unhappy with the Labor Commission, our offices are flooded with disputes or complaints. And so is the Minister's office, and so is the Executive Director's office. When a person is not aggrieved by a decision of the Labor Commissioner, there's only one route. We would, I think, generally people will think, okay, there's a minister, so we will go to the minister,
Yeah.
or we will go to the executive director in the Ministry of Labor. Unfortunately, the arbitration process in terms of the Constitution of Namibia is a tribunal,
Yeah.
a legal tribunal, and the actions that tribunal, the arbitration process or the arbitrator takes is subject only to the review of the Labor Court. So is the decisions of the Labor Commissioner. So I think it's a good question because I need to impress that it will not help to go and sit the chairs of the minister's office warm. If you are unhappy with what the Labor Commissioner decided, you have to approach the Labor Court. I'm talking to parties and I say, yes, you can make a lot of noise. It's okay, you are frustrated. But to be able to get effective relief, you have to approach the Labor Court. In terms of, one example is in terms of Section 63 of the Labor Act, this is now where, for instance, trade unions or employers' organizations do not comply with their obligations in terms of the Labor Act. Yeah. Because once they register, they must submit annual returns. And they must have their books audited because they are dealing with public funds. I mean, my $2 or my $10 monthly fee that I pay for a union as a membership fee, there must be some control. So in terms of the Labor Act, they must submit. Now, the Labor Commissioner can decide once he has given them opportunity, they talk and so on, he can then decide to deregister them, to withdraw the registration. Okay. Now the party is unhappy. You will, of course, see, oh, Honorable Utonius, they let me go there because we are comrades or something.
Yes.
You have to approach the Labor Court. The minister cannot do anything. The executive director will not be able to do anything. Apart from calling me, we will talk about it and I will explain that, yes, Minister, yes, we must go to the Labor Court. Because in terms of Section 63 now, in such a scenario, just to be quite clear, Section 33 in such a scenario say any person aggrieved by a decision of the Labor Commissioner made under this part of the Labor Act may appeal to the Labor Court against such decision. And that's the general's position. Yeah. When a person is aggrieved by the decision of the Labor Commissioner, he or she has the right to approach the Labor Court for effective relief.
Okay. Mr. Sasele, what remedies are available then to a person who is aggrieved by the award or decision of the arbitrator?
Thank you very much for the question. Such a person have to approach the Labor Court for a review of the decision of the arbitrator in that award, or have to approach the Labor Court for an appeal. So it's either you appeal or it's a review, but it's done at the Labor Court. There is no need for a party, if not happy with the award received, to approach the supervisor of that particular arbitrator. You just have to go to the Labor Court.
Okay. So it's like one of those things where the next level is just the Labor Court, basically, if we are to consider the aggrievements and so on. Okay. As we round off our program for this afternoon, I would really do an injustice if I don't ask this particular question. Ms. Sihlahla, what bearing do criminal matters have on labor matters?
Criminal matters and labor matters are two different things. The criminal matters per se do not have any bearing on labor matters. For example, if an employee was working at a certain farm or at a certain company and happened to steal something from the employer, that would be a theft case. Labor matters do not involve like issues like theft. Theft, it's a criminal matter which will be dealt with at a different forum. For example, the magistrate court, the labor court, or the high court, depending on the magnitude of such theft involved. So if now an employee is accused of stealing, the employer will deal with that, will report the employee to the police, and the employee may be arrested. But the employer may also dismiss such employee. So when such employee is dismissed and the employee is of the view that I have not committed such crime, I have been dismissed unfairly, whether there are no reasons to advance that dismissal, or the procedures have not been followed, such employee may then refer a dispute to the labor commissioner. And then the employer may not, cannot say, no, I'm not coming to hear this matter because there is a criminal matter which is in court, in the high court.
Wow.
Because the burden of proof or the standard of proof are totally different. In criminal matters, the burden of proof is on the or is beyond reasonable doubt, while in labor matter is on the balance of probabilities, where the arbitrator then weigh the evidence and determine which evidence is more probable. While in a criminal matter, you have to prove beyond reasonable doubt.
Wow. Ms. Sihlala, you've just taken me right back to school. If we start talking about probabilities and balances, you're reminding me of research methodology.
Yeah.
But it's great to know that, every single day, and I live by this, every single day we learn something new. We learn something new, and with that, I would like to say thank you very much to our panelists who availed themselves to come and teach us further, remind us more about what is out there, what they do, and what is available to us as Namibian citizens. Thank you very much. And with that, we have come to the end of our session for this afternoon. From myself, Shianua Desire Kahia, along with my production crew, it is bye-bye till Monday.